Docket number SJC-13487, Commonwealth versus Ralph Brown.
Okay, Attorney Hartquist.
Good morning, Your Honors. As you know, my name is Richard Hartquist. I'd like to thank you for allowing me the opportunity to advocate on behalf of Ralph Brown. My brief is a five-part, bit of a bear of a brief, and I would like to spend the majority of my time arguing the first section, which discusses the voir dire issue surrounding motive, and I'd like to discuss the directed verdict section. But before I do so, I would say that one of the reasons that there are five sections in this brief is because I've had many communications with Mr. Brown wherein he has reflected that it seemed like every single phase of his case had some degree of prejudice to his defense. So one section regards the affidavit, the warrant affidavit, where a judge found that some of the language was a little misleading. Then we go on to the grand jury testimony where the judge found that there was inappropriate discussion during the grand jury by the lead detective, Mr. Moriarty. I raised the issue of the motive questions that were directed at the jurors. Then we get to the directed verdict phase. Then we get to the prosecution's closing argument. So it seems that every portion of this is tainted, and I respectfully ask the court to consider globally or holistically all the arguments being made because they occur in so many different places. But if I may, I'll start with the voir dire argument, and I would argue respectfully that voir dire is about the jurors. It's not about the case. The idea is to find impartial jurors. And one of the things we love about our jury system is that it's diverse. We get people from different socioeconomic backgrounds, people with different views on issues such as motive and issues such as CSI, or what we really appropriately should call forensic evidence. So we want that diverse jury. We don't want the jury to think about facts before we even have opened the evidence.
Are you going to focus on the first four, the first three, or are you saying everyone on the jury was problematic?
It's a good question. I'd focus on the first four primarily. My argument is that it's problematic throughout the entire trial. But because the federal and state law says that even if we have one bad juror, we have not protected the defendant's rights appropriately.
Well, we don't want to call them bad jurors.
That's fair, Your Honor. I apologize. So yes, I'd ask that you focus on the first four. One of those was an alternate. Juror in seat number one ultimately became an alternate. We don't have extraneous factors in this case that demand voir dire. And this court has set up classifications where we think we need to inquire of the jury if we have racial concerns, ethnic concerns, language barrier concerns, right? Obviously, some sexual crimes can be particularly disconcerting, so we want to ask jurors about those things. Those are questions about the juror to make sure the juror understands. Now, this court has said that with regard to CSI effect, the question should be asked sparingly. And I'd respectfully argue that with regard to motive, it shouldn't be addressed at all because it's already addressed. It's in the jury instructions. We talk about inferences in the jury instructions. We talk about motive in the jury instructions. And we read on more than one occasion the elements of the offense. The appellant concedes that motive is not an element of this offense. We understand that. And the jury's going to hear that in the instructions. What the jury doesn't need to hear is before they're even seated that, listen, there's no motive in this case. I can't give you any motive. Can you still convict? And the word convict is in there, and the word convict has been clarified by this court as being not a favorable word to use when we're talking to them. So what effectively happens is it looks dangerously like a commitment question. Can you still convict if, right? And it almost makes it sound like conviction is the only option.
How many prospective jurors heard that formulation of the question?
I would say one.
Okay.
Okay, and that's in my brief. Not only are we asking them if they can convict without hearing...
Was that juror the alternate or not? That juror was actually seated?
Yes.
Which number was it? Because I know the questions changed a little bit with
They-
each of the four.
They did vary.
So is it the third, maybe? I
It was not juror one. That's all I can offer, and I apologize. I
yeah,
can-
no. It's fine.
So the prosecutor says, I just want to ask you a question regarding motive, and then in each case asked 3 questions, extensive questions, an entire paragraph in the transcript, addressing it in different ways, but clearly saying, look, I don't have motive, can you still convict? And what concerns the defense is that the judge is sitting right there, right? We have 2 attorneys, we have the we have the juror, and we have the judge. And the judge is tacitly conceding at this point that I understand there's not going to be any motive. We're still going to have a trial. This defendant could still be guilty despite the fact that there's no motive. Now, motive's an important consideration in all murder cases, and when it's a consideration that is favorable to the prosecutor, then we will hear extensive motive evidence.
In the jury instruction on motive, what is it exactly, and how does it differ from the question that was asked?
The jury instructive on motive essentially says, right, that motive is not an element of the crime, but the jurors can consider whether or not there is motive, right?
Do you think it's improper to ask a question that would probe a juror's feeling about the absence of motive evidence to any degree? So, for example, set aside the word if they ask the question, would you be able to convict? But there was, if I recall correctly, a question that just said, if there was no evidence of motive, but you had all the other proof beyond, all the other elements were proved beyond a reasonable doubt, how would that make you feel? Do you think, I guess I'd like to understand, is it your position that that question is improper as well because you just can't inquire into motive at all? Or is it tying the inquiry into motive to the possibility of rendering a verdict of conviction? Is that the problematic piece?
I would argue that it does not necessarily need to be addressed at all during the voir dire process, because we're going to instruct them on it later. And I'll add to that, reasoning is simply this. If we tell a juror, you're not going to see any forensic evidence, are you still capable of making a fair decision on this trial with or without that forensic evidence? Forensic evidence isn't motive evidence. Motive evidence is like lay evidence. People know what motive is. People don't know forensics, and our community has been inundated with these crime shows and crime novels, and they learn about forensics, and that's always the door-breaking information that changes the case, right? So while forensics should be used sparingly, I'd respectfully suggest that motive shouldn't be used at all.
So how would we, if we were to adopt that, what would be the general legal principle that you're advocating for? Because this would be a curtailment on attorney-directed voir dire, what you're asking for. And my question is, what would be the limiting principle?
I respectfully would slightly disagree with Your Honor that we'd be curtailing anything, but the legal principle that I'm advocating for here is that we're not introducing trial facts during voir dire before the lawyers have even opened. I mean, the jurors now know that we're going to have a trial, and we're not going to hear anything about motive. They've been introduced information from the trial. Now, I'd argue also that what we have is a prosecutor who knows he doesn't have motive. He wants to patch that up as early as possible.
But we often, even in the prohibited race and sex, those are also introducing factual issues out of the trial, right?
But hasn't this court described those as extraneous issues?
Yeah, but motive doesn't, you go back to your TV show analogy, motive is often a big issue on TV in these TV trials, right? So it has the same potential as forensics of being confusing to, ordinary people, right?
Well, I'd argue that it's different, and it's different in the sense that forensics is scientific. Forensics requires experts. Motives does not. A judge can explain to a juror what motive is quite clearly, and in layman's terms, and the juror will understand that. And when the juror expects motive, the juror doesn't understand or expect an expert to come and testify the psychology of somebody's motive. I mean, going back to the legal principle question, Rule 6E in the Superior Court, right, says you can't ask about how a juror would decide a case. You can't use hypotheticals close to the facts. For instance, there's no motive. We can't ask questions committing a juror to a result. And we can't ask questions that argue or indoctrinate jurors. My position is that saying we don't have a motive, can you still convict, is like a preamble to the opening statement where the DA says, I'm going to prove this case to you. I'm not going to provide you with motive, but I'm going to provide you with a whole bunch of other inferences or direct evidence.
Let's say we agree with you, because I know you say you have a lot of issues and you've briefed a lot of issues, and I don't want to lose you before getting an answer to this. So let's say we agree with you. We still now have the prejudice component to this, or the framework within which we consider your claim of error. This wasn't preserved, right? And so I know you argue that there wasn't an explicit objection to these questioning, particularly even when the judge brought it up about the judge having a little, I guess you would describe it as just not being comfortable with the way the prosecutor was formulating those questions. There wasn't a specific objection made, so aren't we at the substantial likelihood of a miscarriage of justice framework here?
I actually interpreted it differently than Your Honor did, because before the judge stated that he was uncomfortable, it's my memory or recollection at this point that the attorney for the defense did say, I have a problem with this mode of questioning, it's too much, it's going too far. I don't think he renewed the objection every time.
Wasn't that specifically that it was a cumulative question, at least at that point, that it was said a couple of different times, not necessarily that there was a foundational objection to the prosecution? I believe defense counsel even said, I think in this kind of case, it's a fair inquiry or something along those lines. But assuming that we disagree with you, that it is not preserved and it's a substantial likelihood of miscarriage of justice framework. I know you said we should take a look at this holistically, but just looking at this particular issue, what do we do with that? I mean, if that's a pretty high burden for you.
There's no question about that. Now, I was arguing from a slightly different perspective. I was going to say that the Andrade case, there was no objection. In this case, there was a preserved objection, and it's my position that the defense counsel was objecting in the politest way possible and maybe not being as clear as he needs to be. So I would respectfully ask the court to consider this on the abuse of discretion framework. Certainly the judge has wide discretion, but it was unnecessary to raise this motive issue during the course of the voir dire, because it was going to be obvious to the jury whether or not there was motive, and it was going to be clear to the jury that motive evidence is something that they consider because it's part of the standard instructions.
I think, can we just move on to another subject?
I'd like to move to the directed verdict issue if I could. I think I can encapsulate that one a little more quickly. It's Mr. Brown's position that simply he can't be definitively shown as the driver of the vehicle. We look at the Gonzalez case, where we have a defendant who had been driving the particular vehicle for 3 days, whose cell phone was in the vehicle, who had exhibited both motive, very clear motive, for the victims to be killed, and who had exhibited consciousness of guilt during the course of her investigation or her interview with the police. All right, so we have evidence that Ralph Brown rented a car, and it's part of a stipulation, right? We have evidence that the cell phone which Ralph Brown put down on the rental form was a specific cell phone that the police did the search on. But we also have evidence that
And that phone was tracking the car.
that phone was in the, let's concede that it was in the car, okay?
So I get the idea, okay, he rents the car, and sometimes gives it to people who shouldn't be allowed to rent the car. But he doesn't give his phone to those people, do he? Can't the jury say, well, okay, I buy maybe there's a possibility that he gave the car to somebody else, but did he give his phone to somebody else and the phone followed the murder tracking? Isn't there plenty of evidence to find beyond a reasonable doubt that your client did this?
Respectfully, no. And I believe that I can argue effectively that those are two inferential leaps that we necessarily can't make. We do have evidence.
Those are not reasonable inferences that somebody who rents the car illegally for somebody else and gives his phone and the phone number, and then that phone is in the car when all this happens, that's not reasonable?
Isn't this the exact same facts that we had in the Gonzalez case? In
The
the court in the-
Gonzalez case is,
the court in the-
is that a driver versus a shooter case, right?
Yes.
Yeah, a different
Yes.
kind of case, right?
Well, I think by analogy, we can argue that, look, the only reason the defendant's convicted as a shooter is because bullets were fired from the driver's seat. We can't necessarily infer that he was driving when there's multiple people in the car, as many as 4. There's at least one witness that said there's 4 in the car. We also have the fact that the defendant's primary cell phone, which is a 2038 number, and this cell phone make a communication 1 hour after the shooting and then come together, right? That's why the defense can posit that you can infer that Mr. Brown was meeting the person who had this car to collect the car, and then 2 hours later he returns it, right? So what and Gonzalez specifically says, just because it's a person's car, we can't infer that that person was driving it. People lend cars all the time. In this case, we have evidence that Ralph Brown re-rents cars at a profit.
Did
Right.
the rental contract shed any light on this?
The rental contract showed that the defendant's phone, which is really the Katrina Green phone, right? It's a phone that he shared with his girlfriend, was the number on that rental contract. And that was the telephone that was in the vehicle at the time of the
No,
shooting.
but did it share any light on whether the person who rents the truck is permitted to basically sublet it to other people?
But it's not allowed, Your Honor.
Okay.
Right? But, this isn't really the question at bar, right? The question is, can we opine beyond a reasonable doubt that he was the guy behind the wheel? And I'd argue that...
Well, if the contract doesn't permit anyone else to be behind the wheel, doesn't that bear on that question?
I would say minimally, Your Honor. People rent cars all the time and get tired and someone else is driving it, maybe someone else's name's not on it. He can't go there and say, I'm renting a car for this guy who doesn't have a driver's license or this guy who's underage. He has to go there and put his name on there. The concept of re-rental is something that was in the trial, even adopted to some degree by the district attorney in the closing argument. So if his primary cell phone, which we're told is 2038, I think, is on the North Shore until after the shooting, and then that phone joins the phone that was in the truck, then maybe we can infer that the phone was lent along with the truck so that person could then call him and he could collect the truck and return it, right? Or we could infer, Your Honors, maybe that the
How
defendant
quickly
was
is
in the
the car-
vehicle, but he was in the back seat.
Cars returned, how quickly after the shooting?
3 hours.
3 hours. Mhm. Another factor, right?
Sure. I mean, the Tahoe was returned an hour after the shooting. They went straight from the shooting basically to the dealership. If Mr. Brown has to collect that car, then it's not going to get returned as soon because he has to meet the person, get a ride to it, get the vehicle, then return the vehicle.
But doesn't that change the framework? Because our framework is in the light most favorable,
Sure.
right? But you're grafting in evidence that's in the light most favorable to you, because the only person that puts the other telephone number on the North Shore at some Burger King is the testimony of the defendant's children that he used another cell phone and that's the cell phone that we called him on. And so all of those facts are light most favorable to the defendant, not to the Commonwealth.
That's a fair assessment, Your Honor. And there's also the fact that the defendant presented his own forensic cell phone analyst who explained where the primary phone, I'll call it, was versus the Katrina Green phone. But that brings me back, and I'm almost I'm forced to close. Essentially, just because the phone is in the vehicle doesn't mean Mr. Brown's in the vehicle. And if he is in the vehicle, it doesn't mean he's the driver or the passenger of the vehicle. He could be in the back seat of the vehicle. So a whole bunch of inferences are required in order to put him in the vehicle with a gun and firing that gun. And I would lean very heavily on Commonwealth versus Gonzalez when I make that assertion. I'm close to the end. Thank you for your questions, and thank you for your time.
Okay, thank you. Okay, Attorney Hartley.
Good morning, and may it please the court, Brooke Hartley for the Commonwealth. Before I begin, I would just like to acknowledge members of the victim's family who are here in the courtroom and watching via the live stream today. Jumping into the motive issue, the voir dire questions, the trial judge properly allowed the prosecutor to question the prospective jurors regarding motive evidence. These questions were framed to address the jurors' willingness and ability to fairly evaluate the evidence and to properly apply the law. So each of the questions at issue here was premised upon the fact that the Commonwealth had proved its case beyond a reasonable doubt. And if the juror found that the Commonwealth proved its case beyond a reasonable doubt, the questions asked, would lack of motive evidence prevent you from returning a verdict?
What about the question where they were specifically asked, could you convict?
So I think in certain contexts, to say, can you convict, can be an issue. In this context, the question was simply asking the jurors if they could follow the law. So if you look at, I think, Andrade is the case that's most helpful to the Commonwealth here. That question was, the court found no abuse of discretion, although the court did find it wasn't necessary because there were other instructions. But the question, I think, is helpful to the Commonwealth. Would the fact that you would not hear eyewitness testimony to the actual shooting in and of itself prevent you from finding the defendant guilty? If the Commonwealth, through circumstantial evidence, is able to convince you beyond a reasonable doubt of the defendant's guilt. And the court there said that simply because a member of the jury veneer answers that question, that he or she is capable of returning a guilty verdict in the absence of eyewitness testimony in that case, doesn't necessarily mean that they will. And I think that's exactly what we have here. Contrary to what the defendant argues, this is not a juror expressing a willingness to convict. Rather, this question sought to identify jurors that could not convict when the Commonwealth met its burden, that we're going to add this additional element and hold the Commonwealth to a burden that does not exist. This type of question is exactly what jury voir dire was meant to do, to find jurors that are not capable of following the law. So someone who concludes that the Commonwealth had met its burden, yet still requires motive evidence in order to find the defendant guilty, that's not a fair and impartial juror. That's not a juror who is able to follow the law. And I think that the contrast between this case and Montgomery, a recent decision out of this court, is also instructive here, where that question was asking prospective jurors if they could convict based on anticipated eyewitness testimony, but without forensic evidence. And that question didn't have the added element we have here of if the Commonwealth met their burden beyond a reasonable doubt. This question, the court found, was a hypothetical that in some ways sought to commit the juror to in advance to convicting the defendant, especially because the evidence, the added mention of eyewitness evidence made the hypothetical extremely close to the facts of this case. That's not what we have here. This is more similar to Andrade. If the court has no further questions on motive, I can move on to the next issue. I can jump to sufficiency since that's where my brother left off.
That would be helpful because, you know, one of the things about this case, it is eerily reminiscent of Gonzalez, right? We have a situation like we had in Gonzalez where the defendant rents through some app-based application. That phone is what's used to turn the car on. We had evidence of that car tracking ultimately the person or the vehicle where the victim was killed. And then we also have that same phone through the car tracked all the way back here to Government Center. And then there's video of the defendant actually leaving after the car was. I'm trying to find a meaningful distinction here. And I know there's all of these other circumstantial things, but it seems like we still have those same basic facts.
So I think Gonzalez is distinguishable. So first of all, in Gonzalez, there was no evidence that the minivan used in the crime was actually the minivan that was the defendant's mother's in that case. Here we have a concession that this car that the defendant rented is in fact the car that was used in the commission of the crime. We also were on different footing in placing the defendant in the car at the time of the crime in Gonzalez. There was no evidence there that the defendant maintained exclusive control of the car, and I know we have some evidence of that here, but I would argue that it's different because in Gonzalez, there was evidence that on the day of the murder, the co-defendant had driven the car twice. I think twice without the defendant in the car and once with her in the car. So here we do have evidence that the...
I apologize. I might be conflating Gonzalez with our case from, do you remember the name of that case? The one from right here that we vacated?
I know
the
what you're talking about, but there are three of these cases.
Baez or
Baez and, I can't remember, there are three cases,
Yeah.
all dealing with the same.
Baxter.
It was,
Baxter, yeah.
Baxter might have been. It was the very last one where we vacated the conviction, saying it wasn't enough. I apologize for
Sure,
conflating
that's
those
okay. So, I mean, I think it's important to distinguish
But
Gonzalez.
Baxter, the shooter isn't in the car when he shoots, right? The Baxter.
No, Baxter is different. Baxter is more of a getaway driver
Yeah.
case.
We have,
Right.
we don't, in both of in the other case too, the shooter is outside the car, right?
And I think that's extremely
And not,
significant.
and
So-
outside and not even like right next to the car, they're up the street somewhere in a couple of these cases, right?
Right,
And
right.
Gonzalez, remind me of the facts of Gonzalez, because I can't keep them straight either.
So Gonzalez is a similar case, but I think the issue, it's someone gets out of the car and shoots the victim, I believe. But the issue there, it's different than this case because the court found that we couldn't even place the defendant in the car at the time. Whereas in Baxter and Baez, the court said, yes, we can say that there was sufficient evidence that the defendant was in the car or the driver of the car, but not that they had possessed that lethal intent. And in this case, I already distinguished why we can say that the defendant was at least in the car, unlike.
Is that just the phone, the fact that,
So I think
The phone was in
there's several factors that contribute to the fact that the defendant knowingly participated in the murder. First, it's the fact that the U-Haul that the defendant rented was the U-Haul involved in the murder. I think that's extremely significant. Second is the phone, the CSLI records that established in the light most favorable to the Commonwealth that the defendant was an occupant of the U-Haul at the time of the murder, and that he was communicating with Kyle Gathers, who was in the Tahoe. We have.
Right, I'm trying to crystallize the difference between these cases and this one, which is the shooter here, they're right there when the shooting, the person in the car is there when the shots are fired. There's not like someone leaving the car and
Right.
all the other three cases, there's a question whether the person not only knew they were gonna beat somebody up, but that they were gonna shoot somebody.
Right, and
Here,
that goes to
that ambiguity is not present, right?
No, Your Honor, and that goes to the second part. So I was going through how we know the person's in the car. If the court wants to jump to
No,
how
I
we know
don't-
they
I don't
possess
wanna-
the legal intent.
I
Yes.
want to also understand if you have any other evidence, it's circumstantial, right? That it was the defendant in this car.
So I think
you've got
there's-
the rental and you've got the
The phone, and then the third thing is the consciousness of guilt evidence, that the defendant returned the car 3 hours after the murder, after having missed several rental return dates, which I think just enhances the consciousness of guilt evidence. This is someone who rented the car on December 21st, was supposed to be returned on December 25th, doesn't return it, calls to extend on January 4th, and then ultimately returns it very late after U-Haul had actually started a process to try to recover the car on January 11th.
But I don't want you to, I'm sorry, I don't want you to move on from this part, because, again, I'm not at the intent part. I'm talking about placing the defendant in this car. Again, I get confused with the cases, we had the three of them, but I'm speaking specifically about the most recent case where the car was rented here out of Government Center. We had in that case that the defendant had rented the car, that the phone was in the car because the phone was the conduit by which the testimony was that the car was turned on and off, was through the phone. So we had the phone in the car, we had the tracking, and we also had the defendant returning the car after. So all of those three elements that you pointed to that was sufficient to establish that, or at least you claim, that the defendant was in the car, we had concerns about that.
Just so, I think I wrote that case, but doesn't the shooter is around the block from the car in that case, right? So even if he's in the car and he's the guy, he doesn't know that the other people are gonna go shoot somebody around the block, right?
Right, and I think
That's
that goes to the intent part. And I thought in that case that the court found that there was sufficient evidence that the defendant was was the driver, was the getaway driver at least, but was not convinced that there was.
I think we assumed without deciding that, but in addition to the chief's question, there's also the fact that they're communicating. The phone that he uses to do the renting of the car, right, is on for the 50 minutes around at the time of the shooting with the co-defendant, right? So
Right,
so they're talking to each other as they're following the car, right?
Yes, so not only is it pinging off towers in the area of the murder, but you have these calls, in particularly, most significantly, a 20-minute call that happens about 18 minutes before the murder and ends 2 minutes after, which makes sense when you look at the facts of this case, where you have two cars following the victim's car, one car sort of flushing the.
A reasonable inference is they're speaking to each other about tracking them and coordinating the shooting. Right?
Yes, throughout the entirety of the shooting. And I think that's evident just based on the way the cars pull into the parking lot. The Tahoe pulls in, shooter gets out, goes around behind the victim's car, fires in, the U-Haul loops around the parking lot so that it's facing, watching this happen. So as this other shooter flushes those people out of the car, the U-Haul, the shooters in the U-Haul are ready to essentially finish the job, and that's exactly what happened in this case. And I think the call logs, the phone calls, also just strengthen that inference. So in terms of the sufficiency on the lethal intent, I think first of all, it's a reasonable inference that there were only two people in this car. Now, that comes from the fact that there are, so in the video, you can see one person leaning out and shooting. You can't see anyone else. Obviously, there's a reasonable inference that there's a driver. At one point, defense counsel argues at the trial that you can see, I cite the exact part of the transcript in my brief, that you can see, Commonwealth argues that you can't even tell it's a person, but that you can see sort of a shadow in between the driver's seat and the passenger seat at one point. And he argues that is significant and shows that there could potentially be three people in the car. I would argue that the reasonable inference still is that there's two people in the car. It's not clear that a person didn't just move over or that that's even a person at all. We also have the two sets of ballistics that show that two guns fired shots from that car. So based on that evidence, we don't even need to go into the Baxter, Baez, Watson cases, because the fact that two shooters, if we can say that there were two shooters in the car and two people fired at the victim, the lethal intent is not really in question. If this court does not accept that reasonable inference that there were two people in the car, I would argue that this case is more analogous to Watson than to Baez or to Baxter. And Watson is a case where I think there are a lot of similarities. There's evidence that the co-venturers sort of hatched this plan before with phone calls. The defendant remained on the scene after the shooting. He was not just a getaway driver. He brought the shooter to the street. And significantly, like in this case, the position of the car was important. He used the car to sort of block the road so that other cars couldn't interfere with what they were planning to do.
I may be misunderstanding something, but it's my understanding that the defendant isn't really challenging the intent of the driver of the U-Haul. He's challenging the Commonwealth's proof of the identity of the driver of the U-Haul. Is that correct?
I think it's both. I think the first argument is that there's not sufficient evidence to even prove he was there, but then my brother does cite the Baxter-Baez line of cases in which the court found that there was sufficient evidence that the defendant was in the car, but said that there was not sufficient evidence of lethal intent, which is why I make that secondary argument if the court is to say that there could be more than two people in that car. If the court has no further questions on sufficiency, I could address the Franks hearing or the motion to dismiss if the court has any questions, or of course the closing argument.